Good day, Crime Talk aficionados. We have another great show for you today. First, Luigi Mangione challenges all the evidence in the Pennsylvania case. There's a person of interest in the missing student that disappeared down there in the Dominican Republic. Another teacher story to tell you about. A guy gets 50 years for killing his wife. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And remember, you can check us out anytime on any of your favorite podcasting apps. Now, before we get to the docket, I want to tell you about something. And out of full disclosure, this is the lovely Miss Kristen's young nephew, but he is a young, hard-driving entrepreneur. So I need you to go help him out. Go check him out. Go to myskisign.com. Now, if you are into skiing or just love personalizing your gear, this is for you. It's a site where you can design your own custom ski sign. You can put your name, a favorite quote, or whatever vibe you're feeling. Now, it's crafted into awesome, high-quality signs, all right? They've got sleek styles, durable materials, and it's super easy to create something unique. So whether it's for your ski cabin, gear room, or just to flex your love for the slopes, myskisign.com hooks you up. Check it out, all right? And also, if you're haven't done so already, go to crimetalksearch.com and sign up for that background subscription service as well, because you're going to be able to do as many background searches as you desire while you have that subscription. crimetalksearch.com. All right, let's go ahead and get to Luigi Mangione. So let's open the record for Monday, March 17th, 2025. And yes, Luigi Mangione is challenging everything as it relates to his arrest in Pennsylvania. So, according to the defense attorneys, police in Pennsylvania pulled a fast one on old Luigi Mangione. That's right, the smartest, most sophisticated, good-looking criminal around. He got duped by the police, his attorneys say. And what did they do? Well, when allegedly they arrested Luigi Mangione at the Altoona McDonald's there in Pennsylvania, his lawyer says cops gave him a snack strictly so they could get his DNA. Where have we seen that before, ladies and gentlemen? So his lawyer says that police violated Mangione's rights. And they allege that they seized his bag and rifled through his belongings, telling the public they had found a manifesto. Where'd we hear about that last week as well? The attorneys in New York saying it's not a manifesto. Anyway, the attorney there in Pennsylvania, Thomas Dickey, said the cops who first approached Mr. Mangione that morning on December 9th didn't even have proper legal justification to make contact with him. So it was an invalid arrest, and therefore all the items should be suppressed. In the meantime, Mangione is awaiting trial in New York on charges connected with the December 4th execution-style shooting of the United Healthcare CEO Brian Thompson. And Mangione will still have to stand trial both in federal and state courts in New York on charges from that shooting. Now, the motions filed in Pennsylvania relate only to the lesser charges filed when he was first arrested. But the accusations against the police in Altoona could end up becoming a part of the cases in both the state and federal case. Why? Well, if a judge finds that Mr. Mangione's rights were violated and the evidence should be suppressed, they would be suppressed in the Pennsylvania case, but they are certainly going to make that same argument in both the state and federal cases in New York under the same analysis. And then it gets tricky where one judge agrees and maybe another one doesn't, and could get very interesting. Anyway, the 36-page motion asks the court to exclude evidence against Mr. Mangione, basically saying the officers' combined actions at the McDonald's were designed not only to exhibit authority and control over Mr. Mangione, but also to restrict and totally curtail his liberty. Right? Because that's when you're under arrest. You're no longer free to leave. Anyway, the attorneys argue that at the time of the seizure and arrest, the officers lacked reasonable suspicion to engage in such activity. They quote in their motion, any reasonable person innocent of a crime would have thought that he was being restrained if he had been in the defendant's shoes, they argue in the motion, adding that the officers' actions violated Mr. Mangione's constitutional rights. Now, the lawyers also arguing that Mr. Mangione's DNA samples are fruits of the poisonous tree in regards to an illegal search and must be excluded from the Pennsylvania case. As for Mr. Mangione's belongings that were seized, The attorney said that police obtained various writings, including a red notebook and other handwritten papers, and those documents indicate the accused assailant had been developing a fixation and increasing malice towards the United Healthcare CEO and had been talking about harming the CEO for months, according to law enforcement, as stated in the motion. Anyway, the Altoona Police Department illegally seized the notebook, which allegedly contained numerous personal writings covering a plethora of personal experiences of Mr. Mangione, his attorney writes. And this characterization of Mangione's alleged personal experience and writing is incorrect, improper, and without justification, and has no probative value. And in calling this a manifesto, the lawyer wrote, was done so solely for the purpose of prejudicing Mr. Mangione and put him in a negative light before the public, all in an effort to prejudice any potential jury pool. Well, that sounds like the exact same arguments that they made in New York. It's almost like the attorneys are working together because they know it's a test ground in Pennsylvania. This case, may move forward. It should move forward rather quickly. You think you'd want to get these issues resolved beforehand and see how it carries over in the other cases as well. So if you don't know, Mr. Mangione is accused of gunning down the United Healthcare CEO, Brian Thompson, in front of the Hilton there in Midtown Manhattan on December 4th of 2024. Prosecutors allege that the act was premeditated, targeted, and intended to evoke terror, hence the terrorism charge, and he pled not guilty to state charges as well. He has not yet entered a plea on the federal charges. Now, like I said, he faces 3 separate prosecutions: the New York State murder case, another for federal charges, including terrorism, and a third in Pennsylvania on charges including possessing an unlicensed firearm, forgery, and providing false identification to police. One of his federal charges, murder through the use of a firearm, makes Mangione eligible for the death penalty if convicted, but he is not yet officially indicted and pled not guilty in the federal case, so we'll see where that case is going to go, whether it goes death or not. He already has been appointed a death-qualified attorney there in New York, so just in case, they can start working on all that mitigation. Now, the attorneys in New York have basically set the arguments for the Pennsylvania lawyers, since they made the basically the same arguments in a courthouse in New York last month as well. And in the filings, the attorneys in Pennsylvania also argue that when police confronted Mangione in the McDonald's, it was premised on pure speculation and based on a hunch. When the Altoona police were dispatched to the burger chain, they were responding to a call about a suspicious male that resembled the suspect who shot the CEO. He was described as wearing a beanie and a medical mask. The call came after a 5-day manhunt for the CEO killer, but other than an anonymous 911 call, the police had no independent corroborating evidence that Mangione was in fact the suspect sought in the New York case prior to or at the time that the stop and the investigative detention took place. According to the defense attorneys, officers had no objective grounds for the detention other than a hunch and unparticularized suspicion, he added, which gets very interesting, ladies and gentlemen, right? We have this guy who's basically being hunted across the country. He fits the general description, right? But what did the police have upon it? Now, reasonable suspicion is would a reasonable person believe that somebody has committed a crime, right? They go up. It's kind of a no harm, no foul kind of thing. I think is the way the court will analyze it and say it was a tip. He fit the general description. Let's talk with him, see if we get some identification. Mangione then gives false identification. It turns out to be false. And then at that point, there's certainly probable cause to arrest him for that particular crime, whereupon then they find out his true identity. But the interesting issue becomes whether there was a tip. Think about it. We have report every drunk driver immediately. It's called a ready report. So you see a car driving down the road, you call the number and says, hey, this person's driving erratically. They are drunk. Here's a license plate number. Well, the police officer just can't pull you over based upon that anonymous tip. They have to basically see some poor driving, pull the person over based upon that tip. So it does get a little interesting. It's a straight-faced argument that they're making for Luigi Mangione. We'll see if it comes forward, because obviously what they're trying to suppress is not only the arrest in Pennsylvania, as well as the contents that were collected, the gun, the writings, etc. It has no real effect in the other jurisdictions. Let's just say, hypothetically, that the court in Pennsylvania suppresses it, says it was an illegal search seizure of Mr. Mangione. that does not preclude the other courts from still going forward and finding that there was a rational basis, reasonable suspicion to make contact with Mr. Mangione once they find out who he is, that there's an arrest warrant, so it'll all stand. We'll have to wait and see if a district court judge in Pennsylvania will ultimately suppress all that evidence. Take it from me. Most judges don't have the chutzpah to suppress evidence, ladies and gentlemen, so we will definitely have to wait and see. Next, we have a person of interest in the case of the missing young student down there in the Dominican Republic. An Iowa man who was the last person who saw missing University of Pittsburgh student Sudishka Konakai is fighting for his freedom after having his passport confiscated, or depending on report, you believe whether he surrendered his passport to the authorities there in the Dominican Republic. Now, Joshua Ribby was spotted at the Rue Republic Hotel in Punta Cana, where he is under police surveillance, and was told overnight Monday that he hopes just to go home. Now, he has since filed a habeas corpus in the Dominican court, demanding to go before a judge to challenge his detention. He is due in court tomorrow morning. The St. Cloud student has not yet been charged, nor has he been formally named as a suspect in Sudishka's disappearance. But his confusing and contradictory statements to police about what happened on the night of Sudishka's vanished have led, obviously, some eyebrows to be raised. Mr. Ribby was the last person to be seen with Sudishka shortly before 5 a.m. on March 6. They had gone to the beach after a night of drinking with friends. He told police that the pair went for a swim and were knocked out by a large wave. He claimed he used his lifeguard training to drag her back towards the shore, but that was the last time he saw her. She was waist deep in water. Apparently, he managed to get out and then passed out on a sunbed, he told police. Well, guess what? Sudishka was never seen again. Now, experts say the story is unlikely that her body would have washed up by now if she had in fact drowned. And surveillance camera footage from the all-inclusive 5-star hotel showed both Ribby and Konakai vomiting at a bar about 4:05 a.m. on March 6th before they walked to the beach. A second camera spotted Mr. Ribby holding a cup and placing his arm around Konakai's back as they trailed the group at about 4:15 a.m. And about 4:55, the hotel security camera system shows the two of them returning to the hotel. The same camera picked up another female friend accompanied by Johnson walking into the building at 5:05 a.m. Now, the surveillance camera would show Ribby barefoot and shirtless as he slowly walked back to his room at 8:45 a.m. with, guess what, Konakai nowhere in sight. Now, Ribby was peppered with over 50 questions last Wednesday and told a prosecutor that he and Konakai had kissed in the ocean before they almost got swept away by a wave. He also said that he saved her from drowning and almost lost consciousness himself. Anyway, he refused to reply to several questions with the prosecutor, probing him over how they could have be sure that he was, being truthful. The young man was also questioned if he knew if Sudishka was able to swim and if she made any gesture or cries in the sea, if he called the police or told the hotel, if he had told his friends about what happened. And what was also asked was how he felt about the situation. Each time he replied, "My lawyer advised me not to answer that question, and I will follow the advice." Before going silent. Weird case, ladies and gentlemen. I know you go to foreign locations. Young girls seem to wind up missing. We give this young man the presumption of innocence. I don't know what happened. I don't know. Obviously, if there was enough evidence right now, they would have charged him. So you got to give him the presumption of innocence. Was he the last one there? Maybe she did go back to the room. Maybe somebody took advantage of her. Who knows? We just don't know yet. We need more information. So let's withhold judgment just yet. But if you think he's innocent, let me know. I just don't know. They haven't charged him, so obviously there's not enough to charge him just yet. Next, guess what? Another teacher case. Please meet Mr. Norman Dunkley. He allegedly touched a 10-year-old girl's chest over her clothing and other children on their faces and shoulders back in 2021 and 2022, making many of them uncomfortable. That's at least according to a report by the city's Special Commission of Investigation. All right. So the 5th grade teacher, because that's totally normal for grown adult men to want to teach small children, and I'll tell you a story at the end. Anyway, the 5th grade teacher also called students baby and watched sexual content on his phone, according to the police. Several students told the investigators of seeing the image of a fully nude adult female on Mr. Dunkley's phone as they dropped their assignments off at his desk, according to the report. But here's where it gets good. Mr. Dunkley, a veteran science teacher at Public School 70 in Claremont Village, was arrested back in May of 2022 on the charges of sexual abuse and forcible touching. Obviously, the school district didn't fire him, right? No, he can't do that. He was sidelined since that time, but he was still collecting his full salary of a paltry $132,000 per year. Now, I'm not sure what that'll get you in New York, but you're still making 6-figure salary, right? Anyway, jumping forward then to January of 2023, the Bronx District Attorney's Office dismissed the charges against Mr. Dunkley because the girl that was allegedly touched on the chest moved out of the state and the prosecutors couldn't find her. The trouble, this case underscores the Department of Education's in New York's failure to fire tenured teachers, even those deemed unfit to work with children. The report notes that it's the recommendation of the Department of Education that Mr. Dunkley's employment with the Department of Education be terminated. The Special Commissioner Anastasia Coleman said in an August 2023 letter to the then Chancellor. The Department of Education officials would not say whether they brought misconduct charges against Mr. Dunkley or held an administrative hearing in which a state-appointed arbitrator decided whether termination or another penalty such as a fine or suspension. But he is reassigned. But at least he's away from children, according to a spokesperson for the Department of Education there. And they say that the behavior is absolutely unacceptable. Apparently, if you're a teacher in New York and you get accused of sexual misconduct, if not fired, you can stay indefinitely in a disciplinary rubber room, as they refer to it as, or you can go to an office, or you can stay at home. Now, the state education department can revoke the license of a teacher found to lack moral character, but Mr. Dunkley currently holds a license to teach in grades 1 through 6. Now, hey, allegation was made, charges were filed, prosecution failed to keep up with the victim. They dismissed the case. That's on the prosecutors. It really is. But if you are a teacher, like I said, I just think it's weird. And let me tell you, I've done this case. I've done this case multiple times, okay? Grown adult men do not normally want to hang out with small children. Ladies and gentlemen, it's just not the way we're all built, okay? So if you got a, 5th grade, 4th grade teacher that's male, that's like 50 years old, and he does it for the children, be afraid. Be afraid. Go get that background search at crimetalksearch.com. My guess is you're going to be happy you did. Most people just don't put themselves in those type of situations, ladies and gentlemen. All right. A man in Texas gets 50 years for killing his wife. So a Fort Worth man has been convicted of murder and sentenced to 50 years in prison after admitting to fatally shooting his wife in the face, then wrapping her body in a tarp inside of the bedroom. Now, the Tarrant County's district attorney's office says her body was wrapped in a tarp for over a week before it was discovered. I hope they had the air conditioning turned up. Anyway, Fort Worth police were called to the home back on April 19th of 2024, where they found Chrisleen Robertson wrapped in a blue tarp, according to the arrest affidavit. The documents also allege that her husband, Christopher Robertson, eventually admitted to the crime. Now, Mr. Robertson's brother told police he had been gone for several days and returned to a very strong foul smell in the home. He told police he found his brother in his room extremely intoxicated with Chrisleen wrapped in the tarp. Anyway, the medical examiner determined that Miss Chrisleen had been shot in the head. Police did attempt to speak with Mr. Robertson at the scene, but apparently he was too intoxicated to understand what the police were asking of him, and he could not provide any sort of meaningful response. Now, Mr. Robertson did call 911 the next day and admitted to the call taker that he was responsible for the murder. You got to love that. He said at the 911 call, "My father-in-law is going to kill me." That's what he said to the 911 caller. He goes, "I actually killed his daughter." Anyway, when police did meet with Mr. Robertson 2 days later and again admitted to police that he shot his wife and told them he wanted to go to jail, and they obliged him. Now he gets the next 50 years in prison. And guess what? Miss Chrisline, the wife that was shot in the head, that was in a tarp, wrapped in a plastic tarp for 5 days before the police ultimately showed up. Yeah, 5 children. So this guy killed his wife and orphaned 5 children in the process. Congratulations there. 50 years? Let me know. Too much, not enough. Next, this day in legal history on March 17th, 1766. It was the first official St. Patrick's Day parade held in New York, marking a legal public celebration that would grow into a significant cultural event, often requiring legal permits and oversight. Yes, a violation of the First Amendment. Anyway, we'll save that for another day. And on this date in 1861, the Nevada Territory is organized by Congress, establishing legal jurisdiction over a region that would later legalize gambling on March 17th, 1931. And on March 17th, 1917, the Jones-Shafforth Act is enacted, granting U.S. citizenship to Puerto Ricans. Obviously, a milestone there for civil rights and federal jurisdictions, those individuals there in Puerto Rico. And on this date in 1978, the Supreme Court rules in Stump v. Sparkman that judges have immunity from lawsuits for judicial acts, a key legal precedent for judicial accountability, right? So even if the judge is absolutely terrible, completely violates the law, doesn't understand the Constitution in any way whatsoever, ruins your business because he makes a mistake on the bench and gets reversed, all that kind of good stuff, doesn't matter. They have complete governmental immunity for those official acts. Sound familiar, ladies and gentlemen? That's right. You get immunity when you work for the government. It's called governmental immunity. And finally, our dumb criminal of the day. A woman was arrested for fleeing police in a convertible and driving without a license while on parole for those exact same crimes. Why does that not surprise me? Anyway, Christina Ann Middlestat was arrested after fleeing deputies when she noticed her swaying left of the middle of the roadway in a Mustang convertible, according to the arrest affidavit. And when they attempted to pull Miss Middlestat over, she sped up and then the pursuit began. At some point, the pursuing patrol vehicle lost Miss Middlestat, but when a different deputy caught up with her, she fled for a second time. According to the sheriffs, due to the driver's reckless disregard for other motorists, a deputy found a safe area and immobilized the vehicle using a pit maneuver. That's where they ram it and make it spin around. Anyway, Miss Middlestat was removed from the vehicle and arrested on charges of fleeing and eluding possession of amphetamine and drug paraphernalia, knowingly driving with a license that has been suspended or revoked. And apparently, it came to the officer's knowledge that she hasn't had a license since 2009. Ms. Middlestat told the deputies that she fled because she knew that if she got caught, she would likely be going to jail for a long time. I love the candor. She may have thought that due to the fact that she was already out on bond for fleeing and eluding and knowingly driving under suspended license that was revoked, that she probably was correct that she's going to go to jail for a long time. So, ma'am, you are our dumb criminal of the day. Miss Middlestat, congratulations, you made it. But one thing, let me just tell you one thing, ladies and gentlemen. There are a few crimes that are lower level felonies, but if you do them, you go to prison. And one of them is eluding. Now, I'm not talking like, oh, I can't pull over and you drive for 50 feet and, you ultimately pull over. I'm talking about where you drive away fast, turn out the lights in the dark so the, helicopter above can't find you, all those, that kind of eluding. The high-speed chase eluding, you get convicted of that, you're going to prison because that is so dangerous. You literally can kill anybody out there. So remember that. Don't elude, just pull over. And like Miss Middlestat saying, oh, I knew if I got caught, I was going to go to prison for a long time. Well, you're right. But you're going to go for even a longer period of time if there's aggravating factors, more than just the fact that you were already out on a case doing the exact same thing. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.